we will, noticing we have a quorum for the Public Safety Committee, we will reconvene and move on. And I know that Senator Dugan had some questions for you, but Senator Dugan is currently not here. And I was pretty liberal earlier. So we're going to move on to some others that are on the list. And when he comes back, if he still has a question, I will open up the floor for him to do so. Thank you, ma'am. All right, next on the list is Ms. Rose McConnell.
Thank you, Mr. Chairman. I am Rose McConnell. I'm an attorney. I don't have Catherine's depth of experience in the criminal justice system. I was with Troutman Sanders for 17 years, and so my general practice is in the corporate and real estate related background. But I have had the experience of being some in the criminal courts and in the traffic courts as part of pro bono projects. And to be perfectly frank, I have been appalled at my experience in the Georgia court system and the way that poor people are treated in the court system and the level of fines that are assessed against people in the court system. And there were some specific things mentioned about the bill and that raised my particular concerns. And without reiterating those things, which I thought Catherine so ably stated, I would like to also mention that I'm not accustomed to being called paranoid whenever I raise concerns about the size of government. And as a fine member and a delegate to the recent GOP convention where we all endorse small and limited government, I like to see that made into a reality. And so when I see language such as at lines 175 and 176 of the bill that says the commissioner of the Department of Community Supervision shall have the authority to employ as many individuals as he or she deems necessary for the administration of DCS and for the discharge of the duties. Then again, respecting the issue of the police powers, which were given, this is again a new agency, so this is not just a transfer, or these are not existing powers because this is a new agency. The commissioner, again, of the Department of Community Supervision may confer all powers of police officer of this state, including but not limited to the power to make summary arrests for violations of any criminal laws, and that's at line 196 of the bill. Again, and this goes to the issue of the size of the government. It says that the director, this is at line 348 of the bill, there shall be a director of the governor's office of transition support and reentry, who shall be appointed by and serve at the pleasure of the governor and receive an annual salary set by the governor. Since we haven't eliminated any of the other state agencies, and now we're creating 3 new state agencies each with their own department heads and who apparently can hire as many people as they deem necessary, it seems highly unlikely to me that this bill is revenue neutral. And again, the director within the governor's office of transition support and reentry, this I'm reading now from lines 360, shall have the right to designate persons to be assistant directors of each unit and to exercise authority as he or she may delegate to them in writing as approved by the board. My particular concern, based on my experience of working with indigent defendants in the court system, has to do with the system of community service, which is addressed in this bill. It's addressed in numerous provisions, so I'll refer to the different provisions. First at line 423, it says that if community service is ordered as a condition of probation, the court shall order, and then it says not less than 20 or more than 250 hours. I think that Mr. Powell must be wholly unfamiliar with the process of the fines that are being levied by the localities now for traffic offenses when we refer to a $600 DUI offense. I was recently in the city of Decatur traffic court, and my client had a speeding violation 14 miles over the speed limit. His fine was $350 plus a 40% surcharge from the state of Georgia that was levied on top of that, and he had already gone to defensive driving school, which cost him $95. So the idea that in some way that people are paying $600 for a DUI offense is laughable, and that is not the fine levels that the court systems are assessing to people here in the state of Georgia. I don't know how that would work out for people who have fines as were assessed in that court that I sat there that night. I mean, my client, as I say, had roughly $500, was able to put that money together, avoid the probation system, and get out with the points and paying the fine. Other people in that court system had fines of $1,200 to $1,600, and they were indigent. They had no way to pay those fines at all. Here, it's $250 hours in a year that the court can levy in community service at $8 an hour. Then they're paying the probation service $44 a month in the city of Decatur. These numbers don't work. I mean, if the judges are really going to have the right to just say, okay, we're not going to charge you these fees. The judge in the city of Decatur court was saying, these are the minimum fees that I'm allowed to assess by law. Are we now going to say to the judges, I don't know, does this bill mean you don't have to assess the minimum fees that we say? I mean, it says because there's not enough hours in the year for people to work and pay these off at the fines, the level the fines are currently being assessed. Another very serious concern with this, when we're asking people to work 250 hours a year, if we look at lines 460, it says that this section shall not be construed as requiring the community service officer to alter scheduled community service based on changes in the work offender schedule. Which means that we are saying that the offender must miss paid work in order to do their community service hours. Which most of the people who are in this position are working at part-time jobs where they are by no means in control of their schedules. They work at the behest of their supervisor at the schedule that they're required to work, and we could, by this provision right here at line 460, cause people to lose their paid employment while supposedly providing them the benefit of allowing them to do community service.
Ms. McConnell,
Yes.
you're at 5.5
Okay, I've
minutes.
got
I'll give you another minute to
and I'm gonna
summarize.
Thank you
if
very
you don't
much.
mind. Yes, ma'am.
I do have to say, and I frankly do think this is shameful, that we do so much about talking about rehabilitation and giving people a second chance in this. And this bill provides at line 1148 that in no event shall any person convicted of a felony be employed as a probation officer either by the private company or by the state. And so I think that says a lot about how we feel about people who have been felons, even if they were 19 when they happened and they're 49 whenever they want to become a probation officer. I think that says a lot about what we think about rehabilitation and giving people a second chance. Again, I have no stake in this matter whatsoever. I don't do criminal defense work. It's my ordinary practice. I don't represent anybody on any side of this issue. I have had experience with this through my clients, and I would encourage you to spend a day in drug court and a day in traffic court and get a real picture of what really goes on down there.
Senator Albert.
If you could stay for just a minute. On 1108, I'm pretty sure that exists in the law today as far as not working right back into probation once you've been on it. But a couple of points in the question. I agree the 250 hours is not enough. I'm not sure $8 an hour is the right amount either. I don't know why we have a limit on it, so I think you're bringing up a very valid point there, that if we're going to give people the opportunity who are not financially able to pay a fine to work it off, that should be better. And I'm not so sure the fines aren't out of bounds either, so I appreciate what you're saying. There is one clarification that I'd like to make as far as budget and hiring. As you know, in Georgia, we have a balanced budget by constitutional mandate. And unlike our friends in Washington who are spending away my kids' and grandkids' future, we actually balance our budget. And we pass that budget every year, and no head of an agency can just hire ad nauseum. They are bound to the budget that we pass in the law. So I just, from a general perspective, I'm a finance guy. Nobody can do that no matter what agency that they're in, but I do hear your other points. Thank you.
Senator Williams.
Yeah, thank you for your comments. One of the concerns that I had when I first read through this bill was one of the things that you mentioned was the ability to defer police power to the employees of the different agencies. And I'm only speaking this, I apologize. Through doing a lot of research, there currently exists in code. For example, the Department of Corrections, which is coming up underneath this DCS, and Code Section 42-9-9.1, it says, "The board may confer all powers of law enforcement officers of this state, including but not limited to the power to make arrests for violations of any of the criminal laws of this state." So the board can already defer this authority to corrections officers, as well as Department of Juvenile Justice in 49-4A-8. Nearly the same thing, the commissioner may designate a peace officer who is authorized to exercise the power of arrest to any employee, and it says that a couple of times. So why does it bother you that it's in this bill, but not already in code section?
Well, I'm not sure that it doesn't bother me that it's already in the code section. I think it's the expansion of police powers. I mean, I have concerns, and I will be back later this week to address other bills. I think that we have criminalized too much conduct, and we have too expansive police powers. And so it's, yes, it's a new agency. Yes, I understand we have the same powers that other agencies have had.
And it's almost the identical people as well.
And it may be, I mean,
It's the identical people coming underneath a different department, but having the same powers.
Senator Washington?
And maybe it's just following up on Senator Alvar's comment that this already exists in law about not being employed as a parole officer, right? I mean, we're not changing that. It's all the same.
That is correct. It makes it applicable to the new agency.
Right. So,
And-
I mean, I don't disagree with you. I mean, 30 or 40 years ago, you had an offense and you want this job. But I'm not sure this is the role or the place to do that in this particular issue.
And I think that it is because there's such an emphasis on rehab and returning people to the community, and that's what the governor says is so important. And that's what that the focus of this has been on criminal justice reform, is to give people a second chance. And I think that it is in fact really important then, if there's a 10-year period or a 15-year period following a conviction and the penalty has been served, then I think that yes, people should get a fresh start. And I think it's a really important part of a reform effort.
And I think the governor is evident in that with his banning the box initiative that he started and that is going on all across this state. So I think the governor's working in that direction, and I commend him for doing that. Any other questions from the committee? Thank you, ma'am.